All right, hello, welcome everybody. My name is Beena Joshi. I'm one of your presenters for today. A couple of housekeeping items as we get started here. If you have any technical issues related to the webinar, please feel free to put those in the chat box that you see available on your screen there. And if you have any questions or comments related to the presentation that David and myself will be giving today, please feel free to put those questions in the Q&A box that you see on your screen. As I said, my name is Beena Joshi. I am a partner in the Energy and Environmental Practice Group at Arent Fox Schiff. A little background about myself. I have a fairly diverse practice across the energy and environmental space that has included, over the past several years, practicing before the Illinois Commerce Commission, including in proceedings related to pipeline approvals and more specifically CO2 pipeline approvals. I'm going to give you a quick overview of our agenda today and then pass it along to David to introduce himself. So there is a lot of ground that could be covered when it comes to carbon capture sequestration and the recently enacted legislation in Illinois that is very commonly referred to as the Safe CCS Act. We have limited this webinar to an hour. So our goal today is to start with just a brief high-level overview of the state of carbon capture sequestration and a high-level overview of the recently enacted legislation. And following that, we'll identify what we consider to be some key considerations, including gaps and ambiguities in the legislation with an eye towards forthcoming rulemakings and next steps in CCS development in Illinois. And with that, I will pass it over to David.
Thank you, Beena. And good afternoon, everyone. As Beena said, my name is David Loring. I'm also a partner in the Energy and Environmental Group at Arent Fox Schiff. And I've been involved in the carbon sequestration sector for a number of years, assisting clients in Illinois with sequestration activities and questions, and certainly am excited to be here to talk with all of you today about the Safe CCS Act and what we see as sort of the future and next steps under that legislation in Illinois. Before we jump into the sort of nuts and bolts of the Safe CCS Act, just provide some framework and high-level overview. For those that don't know, CCS, or what carbon capture and sequestration, is generally known as the capture either directly from the atmosphere or from a stationary source of a CO2 gas stream, the cleaning of that stream so that you are left essentially with just CO2, compression of that gas to a supercritical fluid so that it can be transported via pipeline for permanent sequestration through an underground injection well into the subsurface. Illinois' Safe CCS Act, which was passed just last month on July 18th, is comprehensive in the sense that it covers all aspects of sequestration, from the capture of the gas from the stationary source, the transportation of it through pipeline, and then eventual sequestration into the subsurface. Illinois joins a number of states that already have legislation. Some states are more comprehensive than others. Illinois certainly appears on the surface to be fairly comprehensive. Kansas, Oklahoma, Louisiana, Minnesota, North Dakota, Texas, West Virginia, and Wyoming are the states all that have various degrees of CCS legislation. The distinction being there are only 3 of those states, North Dakota, Wyoming, and Louisiana at this point, that have been delegated authority by EPA to implement what's known as the Class 6 Underground Injection Control Program. So that's the set of regulations that is overseen by US EPA governing one part of CCS, the actual sequestration, the injection of CO2 into the subsurface. Illinois, despite the SAFE CCS Act providing requirements as it pertains to sequestration. It is not a delegated state. It has not received primacy to implement the Class 6 program. So as we'll talk about, or particularly I'll talk about later, sources within Illinois that want to engage in CCS, at least for the foreseeable future, will be having to satisfy both Illinois requirements and US EPA Class 6 requirements. One last thing to note is that in 2011, there still is existing legislation called the Carbon Dioxide Transportation and Sequestration Act in Illinois that controlled the transportation through pipeline of gas, of CO2 gas from, I believe, just coal-fired power plants. That this Safe CCS Act amends that, builds onto that, and my colleague Bina will be talking about that some in a bit. In terms of a brief state of the state, I think the name of the game here is backlog. As we stand right now, and this is based on the most recent congressional report that was issued a few months ago, in 2024, we have 4 federal EPA permitted Class 6 injection wells. Those are located in Illinois and Indiana. An additional 11 wells that have been permitted by states, in those states that have been given authority to implement the Class 6 program. And according to the report, there were 130, though last I checked, I counted 132 Class 6 permit applications that are pending before US EPA. So quite a bit of backlog, and I think the demand for CCS projects is only increasing. Certainly, the incentive, as most people know in this sector, is the availability of the 45Q tax credit, which can provide up to $85 a ton for stationary sources that sequester gas. But that's not the only, so to speak, driver. US EPA in April of this year passed new regulation that governed existing coal-fired power plants and new gas-fired power plants, and indicated in those rules that carbon capture and sequestration is the best system of emission reduction. In other words, the best control for achieving the required 90% reduction in CO2 from facilities that are affected by this rule. So certainly we anticipate continued demand and increased exploration of CCS throughout the country. So with that, Bina, I will turn it back over to you.
Thanks, David. So I'm going to provide just a high-level overview of the Safe CCS Act, starting with some of the issues driving it and themes that are present throughout the Act. So as David said, there is a lot of incentive and motivation out there to help sort of move along the process of CCS development, right? But there have also been some issues that have been holding back CCS development. So one major issue that has served as an obstacle for CCS development is concern over health and safety by community members and local governmental agencies. A fear of possible leaks and ruptures, and local officials' ability to respond in the event of a possible rupture emergency. A lot of this is driven largely by the incident in Sequestration, Mississippi, back in 2020, where a CO2 pipeline ruptured, impacting the surrounding community. This whole issue is sort of further complicated by the fact that PHMSA, the Pipeline and Hazardous Materials Safety Administration, serves as the primary regulator and oversight authority when it comes to pipeline safety, and the fact that PHMSA has initiated a new rulemaking for CO2 pipelines in 2022, largely in response to what happened in Sequestration. So PHMSA's proposed new rule has been written and is currently undergoing review in the Office of Management and Budget. The notice of proposed rulemaking for that rule is anticipated as soon as this fall. But as of now, there is a question mark surrounding the exact scope of the new PHMSA rulemaking, which is supposed to propose requirements based on lessons learned from Satartia. And also how that might interplay with some of the requirements under the Act. Another issue has been acquiring easement rights for pipeline and pore space development. So from the perspective of the owner operator of a pipeline or a sequestration operator, having the ability to obtain eminent domain authority for pipeline development if necessary after good faith negotiations and to avoid holes in pore space acquisition is important, right? What happens when you have most of the pore space that you need, but you have just a few gaps or a few holes in between? What happens when you're able to obtain some of the property rights for easements for your proposed pipeline pathway, but not others? So, and then from the landowner's perspective, obviously there's a concern about ensuring good faith negotiations when it comes to any easement acquisition, and also just compensation for use of their land and any potential damage that might occur to their property. Another issue addressed in this legislation is potential environmental impacts, including, what is required if there is an impact to groundwater from a sequestration area. And then finally, this is an area where potential stakeholders include neighboring residents and businesses and local governmental entities and emergency response entities. And so, part of the legislation includes and expands upon requirements to provide neighboring property owners and governmental entities with notice and creates opportunities for comment and participation from those various stakeholders. There we go. All right, so in terms of the substance of the legislation itself, moving on to sort of some of the more specifics of the Act. And again, this is at a high level, but the Act really, as David mentioned, it's probably the most comprehensive or one of the most comprehensive pieces of state legislation that have been enacted thus far, covering carbon capture and sequestration. And, it appears to have adopted a sort of soup to nuts approach, right? And so it covers everything from the start of the process at carbon capture through transportation of that carbon dioxide via pipeline, and then finally sequestration of that carbon dioxide. David will cover carbon capture and sequestration in a little bit more detail later in this presentation, and I'll talk about pipeline construction and operation in a little bit more detail later in this presentation. But just as kind of a baseline, high level, what the Act is addressing. When it comes to carbon capture, it creates and requires the acquisition of a carbon capture permit for any source that wants to engage in the process of carbon capture. If you're an existing source, you need to show that there will not be a net increase in emissions at the source as part of your permit application. And it also allows the IEPA to propose and the Illinois Pollution Control Board to adopt minimum carbon capture efficiency requirements when it comes to carbon capture. For pipelines, one of the health and safety is sort of a major theme on some of the revisions that have occurred in the pipeline section when it comes to pipeline related requirements. One big outcome of the legislation is halting the Illinois Commerce Commission's ability to issue a certificate of authority for a CO2 pipeline until PHMSA promulgates its final updated CO2 pipeline safety rules, or in the alternative, if PHMSA has not yet promulgated those rules until at least July 1st, 2026. The Act also includes several other requirements that are focused on education and training of local residents, businesses, and emergency response personnel. It provides for an emergency services training course developed and coordinated by the Illinois Fire Service Institute, along with other emergency response and public health agencies. Owners and operators of pipelines are required to coordinate with the Illinois Emergency Management Agency and Department of Public Health on emergency preparedness materials for local residents and businesses within a 2-mile radius of the pipeline, and also to provide or offer training for those individuals. It also requires owners and operators of pipelines to offer annual training for medical personnel in counties located along a pipeline route. Also requires that owners and operators of potential pipelines prepare and submit an emergency operations plan consistent with regulations promulgated by the Illinois Emergency Management Agency, and that plan be created in coordination with local emergency response personnel. The act also includes sort of expanded notification and participation requirements when it comes to pipeline development. So as part of the pipeline authorization process, the owner or operator of the potential pipeline needs to hold at least 2 pre-filing public meetings in counties where the pipeline will be located. There's a requirement to keep a website with the proposed route and directions with how public may offer opinions related to the pipeline. It also expands notification requirements as compared to the 2011 Act. And so you're required to provide notice prior to filing an application for a certificate of authority for a pipeline. Under the Safe CCS Act, notice must be given to property owners located within a 2-mile radius of the proposed pipeline. The previous notification requirements under the 2011 Act were more limited, and they were limited to landowners either on the potential route or the proposed route width, which could be up to 200 feet in width. And then finally, when it comes to pipelines, the Act clarifies that eminent domain authority exists for CO2 pipelines, but it also clarifies that CO2 pipeline owners and operators are not to be considered public utilities for other provisions of the Public Utilities Act, which, as I'll discuss more later, provides some clarification over sort of the full scope of authority that a pipeline owner or operator is required to obtain prior to constructing or operating their pipeline. So moving on, when it comes to pore space, the Act clarifies that underlying pore space belongs to the surface owner, and that, basically there are 2 ways where a developer or, a sequestration operator can acquire pore space. The first is by purchasing the surface estate, or the second is by obtaining an easement from the surface owner. The Act provides guidelines for when surface access is allowed, which is essentially limited to completing activities that are required under a Class 6 permit or a carbon sequestration permit. And an additional access agreement or written agreement would be required with a property owner for access to the surface area of that property for other activities, including to install injection wells or deep monitoring wells, things like that. And then finally, most significantly, the Act includes provisions allowing for the integration of pore space owners' interests to address potential gaps in pore space acquisition. So this helps, will hopefully help prevent that sort of situation where a sequestration operator is able to obtain pore space rights throughout a significant portion of the area where they, they intend to sequester, but have sort of like a patchwork of, maybe certain properties where they have not been able to obtain rights. And so integration can be done in one of 2 ways. The first is by agreement of the landowners, but if for some reason, after good faith negotiations, sequestration operator is not able to obtain the rights that they need from all the property owners, then they can apply for an order from the Illinois Department of Natural Resources requiring integration. And so in order to obtain this order from IDNR, however, there are certain requirements, including that the sequestration operator has acquired rights from pore space owners of pore space underlying at least 75% of the surface area above the proposed sequestration facility. And there are also requirements, obviously, about fair and compensation and things like that as well. Finally, when it comes to sequestration activities, the Act includes permitting requirements for sequestration. These appear to be similar to, but perhaps more stringent than the Class 6 permitting requirements. David will talk more about this later. And there are also requirements for response and mitigation in the event of an emergency, for example, if CO2 may be impacting groundwater. And so with that, I'll hand it over to David to talk a little bit more about carbon capture permitting.
Thanks, Bina. So the first bucket, I suppose, is that the Safe CCS Act covers is governing the actual capture of carbon dioxide from a stationary source, or potentially from the atmosphere. But most of my discussion today is going to be from stationary sources. Capture, for those that are unaware, is essentially a facility that will be built connected to the stationary source that is essentially pulling the CO2 off that source, and if need be, cleaning that gas stream so that what is left is CO2, and then compressing that gas in order for it to be piped and eventually sequestered. But up until now, prior to the enactment of the Safe CCS legislation, these capture facilities, it was generally understood in the air permitting world that a capture facility would constitute either a new source or potentially a modification to an existing source. It would require what's sort of typically called an air construction permit. The Safe CCS Act builds on that. Essentially, it sets forth additional requirements that it appears that an owner-operator of a capture facility wanting to construct such a facility will have to comply with. There are a number of elements. Two are the most critical. The first is essentially a emissions analysis for criteria pollutants, and by that, these are SO2, nitrogen oxide, volatiles, particulate matter, essentially non-CO2 related, non-greenhouse gas related permits or pollutants, excuse me. And that emissions analysis that is required under the Safe CCS Act, and I'll get into a little bit more detail in a moment, requires a demonstration that there will be no net emissions increase based on the construction and operation of the capture facility. The second overarching element for this capture permit under the new legislation is what's called a greenhouse gas inventory analysis. And that is, again, more of an emissions analysis more than anything. It has a requirement, essentially a demonstration that the capture facility demonstrates that there will not be a net increase in greenhouse gas emissions over the lifespan of the project. So both the criteria pollutant analysis, emissions analysis, as I call it, and the greenhouse gas inventory analysis share a common theme, that they are both essentially designed to ensure that the implementation of a CCS project does not have a net harm to the environment and public health as compared to pre-sequestration. There is a water impact assessment report and some additional rulemaking that I'll touch on very briefly, but the two elements, the emission analyses are certainly the most relevant here. So going into a little bit more detail, on the criteria pollutant emission analysis, the Act says, quote, that a permit applicant must demonstrate that there will be no net increase in the individual allowable potential annual criteria pollutant emissions at the source. That is quite a mouthful, and when you unpack it, has a number of implications and questions that I anticipate will be worked out through subsequent rulemaking. The statute also sets forth essentially the authority of Illinois EPA when it's evaluating the emissions analysis that is submitted by the permit applicant to allow what they phrase as a quote unquote alternative demonstration. If the applicant can essentially demonstrate that it is technically infeasible to demonstrate that there is no net emission increase. Somewhat similarly, on the greenhouse gas inventory side, the greenhouse gas emission analysis, the Act requires that any increased emissions based on an annual lookout that are necessary for the operation of the capture facility must not exceed the total amount of greenhouse gas emissions that are captured over the lifespan of the project. And the Act actually goes a little bit farther than that and specifies the three sort of sectors, the three emission points that have to be considered in that analysis. And it's not simply localized, focused on the capture facility itself. The capture facility, the greenhouse gas emissions from operation of perhaps compressors and other equipment used to clean the CO2 gas, certainly those emissions, those greenhouse gas emissions are factored in. That's number 3 on the list on the right of the slide. But also emissions, greenhouse gas emissions from the generating source itself. So the source from which the CO2 is being generated. And then most interesting from my perspective is that emissions, whether they be on-site or off-site, have to be considered, greenhouse gas emissions, from the energy source that is used to power the capture facility. So if the generating source is not actually powering the capture facility, if that power is coming from the grid, from an off-site generation facility, then the greenhouse gas emission impact from that facility has to be factored into the determination that the amount of greenhouse gases that are captured vis-a-vis sequestration over the lifespan of the project do not exceed the amount of greenhouse gases that are generated in order to allow that capture facility to operate. Questions, concerns, interesting things that flow out of this. This could probably take up an entire CLE on its own, but I'll raise sort of a number of things to think about. And when I say that, certainly we expect in the next, most likely in the next few months, and then moving on through 2025, there's going to be significant movement on the part of Illinois EPA and other agencies to begin implementing drafting and proposing regulations to implement this legislation. So these are, I would suspect, a number of the issues that will be discussed during that process. On the criteria pollutant side of that emission analysis for no net emission increase, the term source is interesting to say the least, because it raises questions as to whether the analysis looks solely at the capture facility or whether the analysis will necessarily include criteria pollutant emission increases that are caused or that emanate from the generating source itself. Why does that matter? In the permitting world, the questions as to whether you have contemporaneous projects that occur along with the capture facility, whether those increases from those projects or decreases from those projects, whether those will be accounted for when an applicant is trying to permit the capture facility. If, for example, the generating source intends to increase capacity around the same time that it is permitting the capture facility, will the increase in emissions from the generating facility increase in capacity be factored into Illinois EPA's analysis as to whether the capture facility will cause a net emissions increase in emissions? Similarly, what the meaning of potential is, that is a very defined and storied term in Illinois and in air pollution regulations in Illinois. And what the actual emissions test will be to demonstrate that there is not a net emissions increase in potential emissions, that I suspect will be defined with more specificity in Illinois EPA regulations. And then this alternative demonstration, my suspicion, again, is that sources will have challenges in demonstrating that they demonstrate no net emissions increase. And if that is true, what weight, what requirements will be necessary to get that alternative demonstration to prove that it is technically infeasible to demonstrate that there will be no net emission increase, and will that be applied to capture facilities that are already under construction, are already in the permitting process before Illinois EPA. On the greenhouse gas side, I think the most significant question from my perspective is how this emission inventory analysis, what it will look like when evaluating emissions over the lifespan of the project. CCS projects are essentially limited by the length of time that the generating source is operating, and then by the amount of pore space that is available, but certainly 5, 10, 15 years of operation is plausible. And over that course of time, changes in the power that is used to power the capture facility can change. And so I think there will be questions in the permitting analysis as to how that inventory is determined over the lifespan of the project when things are likely to change over the course of the project's lifespan. One other thing I'll note in the section of the Act governing capture permits, it does authorize Illinois EPA to engage in rulemaking to propose, quote, minimum carbon capture efficiency rate for carbon capture projects. Unclear to me what the form of that rulemaking or what those requirements might look like if Illinois EPA decides to go down that path. Whether those would force technology requirements, and whether those technology requirements to ensure a minimum level of capture would be applied retroactively to existing capture facilities or those already engaged in the permitting process. I think with that, I can turn it over, Bina, to you if you have control over the screen.
Let's see. One moment here. There we go. All right. So I'm going to talk a little bit more about some of the key considerations and issues for CO2 pipeline development, starting with who needs to obtain a certificate of authority to construct, operate, or repair a carbon dioxide pipeline. So as written, the Act would appear to require any person or entity constructing, operating, or repairing a carbon dioxide pipeline to obtain a certificate of authority from the Illinois Commerce Commission, unless it fits the definition of a legacy carbon dioxide pipeline. And a legacy carbon dioxide pipeline under the Safe CCS Act is defined fairly narrowly as a CO2 pipeline constructed before July 1st, 2023, that is less than 1 mile in length and is located on property entirely owned by the pipeline operator. Meaning a certificate of authority would be required for other pipelines regardless of length or the property they traverse. Additionally, in previous CO2 pipeline proceedings, certain parties had made arguments suggesting that a certificate of good standing, which is a license required under the Public Utility Act for common carriers by pipeline, was needed in addition to a certificate of authority under the Carbon Dioxide Transportation and Sequestration Act in order to construct and operate a CO2 pipeline. This legislation clarifies that a certificate of good standing is not required. And so the only ICC approval required for pipeline construction and operation is a certificate of authority under the Carbon Dioxide Transportation and Sequestration Act as amended. Also, previously, it had been suggested and argued that the 2011 Carbon Dioxide Transportation and Sequestration Act was available only for owners and operators engaging in CO2 transportation related to Illinois coal. The statute as revised through the legislation now makes clear that it is available for any CO2 transportation, including, for example, ethanol, other than for enhanced oil recovery. Thus, it clarifies the authority to construct a CO2 pipeline is open to other interested parties in other industries, including ethanol, cement, steel, etc. So another key issue is the scope of Illinois Commerce Commission authority over health and safety issues. Here I have two provisions from the amended Carbon Dioxide Transportation and Sequestration Act up on the screen. And so the first provision notes that the commission shall not issue a certificate of authority under this act unless PHMSA has adopted the final revisions to its pipeline safety rules, and the commission has verified that the submitted application complies with those finalized. In the alternative, if after July 1st, 2026, PHMSA hasn't adopted its final revisions, then the commission can approve a certificate of authority under that section. However, in that case, it can only approve a certificate of authority if it is compliant with any requirements or conditions adopted by the commission under subsection G5. And if you look at subsection G5, it notes that when the commission grants a certificate of authority for a pipeline, the commission shall adopt such requirements or impose such conditions upon a certificate as in its opinion, are necessary to preserve public safety. So as written, these provisions seem to provide a little bit of an expanded role to the Illinois Commerce Commission and its authority over regulating CO2 pipeline and public safety. So G1, asks the commission to verify compliance with PHMSA requirements. It is fairly common for the commission to require compliance with any necessary federal approvals or authorizations as a condition to granting authority to construct or repair a pipeline. However, typically that has meant ensuring that the applicant has just received or will receive any necessary approvals or authorizations. Here, the statute requires the commission to verify that the submitted application complies with the finalized PHMSA rule. So this means that the applicant will need to include a showing of compliance as part of its application. And it also opens the door to the commission needing to do a bit more than just making sure that a particular, potentially doing a bit more than just making sure that a particular authorization or approval is granted. And exercising a little bit more oversight authority. And G5 goes even further. This provision appears to leave room for the Illinois Commerce Commission to impose requirements to, quote, preserve the public safety beyond those required by PHMSA. And the scope of what this could be or entail is left pretty open. The only limitation being that it must be compatible with PHMSA requirements. This is new authority. With respect to interstate pipelines, it could leave that are open to potential preemption issues. And so it's just sort of an open area, what exactly is the scope of the ICC's authority when it comes to this provision? How might it be implemented? Moving on, another requirement in the Act for owners and operators of pipelines or potential pipelines for the transportation of CO2 is to use modeling to develop a risk-based assessment and a chemical safety contingency plan. The Act is, again, somewhat light on details regarding what this plan should include, but seems to indicate that it would entail some type of plume modeling that would account for pipeline-specific characteristics, local geology, geography, and weather conditions. You're supposed to account for vegetation, wind, ambient conditions, various obstacles that might exist, such as buildings, the type of terrain that exists within a particular area, and various weather contingencies that could impact the concentration and direction of the CO2 release in the event of a leak or a rupture on a pipeline. This type of assessment is probably something that folks who develop larger pipelines are familiar with. Folks who don't work on larger interstate pipelines may not be as familiar with this type of modeling. The legislation does not dictate that any particular type or method of modeling must be used. It does, however, note that the results of this assessment, right, the risk-based assessment and chemical safety contingency plan must be made public on IEMA's website and must be shared with relevant counties. One concern that we might see here is that with pipeline information, sometimes there are confidentiality concerns regarding information, particularly that could present a risk to security. So for example, you don't necessarily want terrorists to have information regarding what they might be able to do to hit a pipeline in order to do the greatest possible damage to the surrounding area, right? So this is an area where the benefit and desire to have information publicly available may need to be balanced with potential safety concerns. So, similar to what David was talking about with carbon capture, when it comes to pipeline development, there are, several areas of open questions that remain, both for potential future rulemakings and also, to the extent not addressed in rulemakings, that may end up being themes in future proceedings before the Illinois Commerce Commission for CO2 pipeline approvals. And so, the Act does provide for the Illinois Commerce Commission, it provides them with authority to adopt any rules and procedures that are necessary to enforce or administer the provisions of the Act. One of the topics that it specifically calls for the commission to adopt rules for are fees to support the Illinois Commerce Commission and IEMA costs associated with implementing the Act. This includes adopting rules for an annual fee plus an additional, an annual fee that's like a base fee per pipeline plus an additional fee per mile of pipeline that would apply to any CO2 pipeline granted a certificate of authority. And these funds are meant to support the commission and IEMA's costs for compiling and maintaining emergency response plans, training, equipment for first responders, things like that. So, also, as I mentioned previously, there remains this open question of the scope of conditions that the Illinois Commerce Commission might be able to impose in order to preserve the public safety and how that might interplay or could interplay with PHMSA regulations. There are also various components and requirements that will be required in emergency operations plans, but there's sort of like an open question that remains, right, of what is the full scope of what needs to go into an emergency operations plan. Also, what is the level of coordination that is required with local emergency response? There is a requirement that there be a coordination, but, are there limits to what that coordination might be? Is there a minimum amount of coordination that may be required? How do you show that you've engaged in good faith coordination with local emergency personnel in developing your emergency operations plan, and your training. Also there are some open questions when it comes to notice provisions generally. What exactly are the requirements to comply with the Act's notice requirements, showing that you engage in good faith efforts to identify property owners that require notice. Also, there's one notice requirement that requires notice to each unit of local government. How should that be interpreted? How do you interpret what a unit of local government is? How far down do you have to go in terms of the entities to whom you're providing notice? So, these are just some of the open questions that remain for future rulemakings and proceedings. And I'll hand it over to David now to talk a little bit more about carbon sequestration permitting.
Thanks, Bina. The last prong, so to speak, in this pipeline, no pun intended, but I had to use that, is the sequestration part of the process. As I mentioned earlier, Illinois does not have authority to implement US EPA's Class 6 program, which also oversees the sequestration of CO2. Nonetheless, the Safe CCS Act essentially serves to provide a complementary but more stringent, broader program for governing sequestration activities than perhaps is required under the federal level. I think it's based on the reading of the legislation, at least it appears that way. Whether that will be clarified through rulemaking or whether that will just be clarified sort of in practice as applicants in Illinois for sequestration go through the process of getting a Class 6 permit as well as authorization for sequestration before Illinois EPA. That will sort of essentially be borne out in the next, I would imagine, couple years as this process works through. There is generally a greater focus, as Bina alluded to earlier, on safety and emergency planning, which is not surprising. The breadth of some of and I'll get into this with some more specificity, but the breadth of some of the plans and reports that are required to be submitted in order to get a sequestration permit in Illinois focus not merely on impacts to groundwater, but go beyond that. With an intent, I believe, to ensure that surrounding communities are protected and that there is at least knowledge and planning that is established before sequestration occurs in order to minimize the potential risk to those surrounding communities. One question that actually came in that is relevant just before I speak, I go a little bit further, but it's relevant to the sequestration permitting as well as the capture permitting, was the question of whether Illinois EPA is required essentially to implement rules for the sequestration and for carbon capture. And there is nothing under the Act itself that mandates that Illinois EPA promulgate rules to provide more specificity than the Safe CCS Act. Whether Illinois EPA actually does that, I think there are some, as I mentioned, some open questions and issues to address, but whether that's accomplished through rulemaking or whether that's accomplished just through the permitting process, certainly time will tell. There we go. What I've done here is we do not have, unfortunately, the time to go through in detail all of the various plans and reports that are required as part of the sequestration application under the Safe CCS Act. The left column on this slide reflects the plans and reports that are already required by applicants to submit as part of their Class 6 permit application before US EPA. There is language in the Safe CCS Act that says, quote, this, the submission of or the satisfaction of these 6 or 5 plans, I should say, listed on the left, may be satisfied by submission of copies of documents provided to US EPA in accordance with the Class 6 program. So there's clearly an intent, or was an intent by the legislature, to minimize the burden on applicants on having to duplicate plans and reports that are submitted on the federal level and on the state level. On the right side, whether this was intentional or not remains to be seen, but there are 2 plans, or one report, an air and soil gas baseline condition report, and then a remedial action plan. I'll get into those in a little bit more detail, where that language does not appear in the act, that those plans, that report, can be satisfied by what is submitted under the Class 6 program. So I think there is at least some indication, some signal from the legislator that the mandate on applicants wanting to sequester CO2 in Illinois will be more stringent than what is required in the Class 6 program. And certainly there's it's in everyone's sort of best interest that wants to engage in sequestration to have open lines of communication with both agencies to sort of minimize the overlap in planning. In terms of the differences that appear, at least facially, between the Illinois Safe CCS Act and the Class 6 program when it comes to sequestration permitting, the air monitoring plan and the soil monitoring plan are permissive under the federal program, although my understanding is most sources are submitting those plans, but they are mandatory under the Safe CCS Act. The emergency response plan, that has to be submitted in Illinois to IEMA and I believe one other agency in Illinois prior to submitting the application for sequestration to Illinois EPA. And it requires that the applicant establish a sensor and alarm network that is going to be based on sort of resources and infrastructure that has been identified near the sequestration activity that might be impacted by a potential release. This certainly relates back to the modeling, the terrain modeling that Bina was discussing a few moments ago. While that modeling pertains to a release from a pipeline, certainly the pipeline is connected to the sequestration facility, and at some sites, the capture facility, the pipeline, and the sequestration facility may be located within a mile or 2 mile radius. And so emergency response planning and even this remedial action plan that is required under the Illinois Act may, by necessity, include and have to evaluate and set up monitoring networks to address and address and identify any releases that would occur not only from a sequestration activity, but from the pipeline itself. The remedial action plan, one thing that I found interesting, and that speaks to the broader nature of the Illinois SAFE Act as compared to the federal program, is that while the federal program, at least the Class 6 program, seems to focus more on impact to drinking water, to groundwater, the remedial action plan under the Safe CCS Act is not so limited, and it requires identification of all actions to address air and soil impacts from a potential release. And one additional thing to note on that is that it requires essentially a demonstration in that action plan that the remedial actions or the corrective actions, the equipment that might be used to respond to a particular type of release, that those are demonstrated in the plan to be reliable and to have sufficient capabilities to address the potential worst case scenario. One other interesting thing I'll just point out is that in terms of financial assurance under the Illinois SAFE Act, under the Class 6 program, insurance is an available option to demonstrate financial assurance. It does not appear to have been listed under the Illinois SAFE Act, so that's just something to keep in mind. Open questions and considerations. Again, future rulemaking is possible, not necessarily required. So these will be, these might be questions that are merely addressed vis-a-vis the permit applicant and the agency directly. I think the biggest question mark, perhaps, is going to be the coordination between US EPA, Illinois EPA, and the applicant, and what, for example, might happen where a plan is submitted under the Class 6 program, is approved by US EPA, but then Illinois EPA under the SAFE CCS Act raises questions and requires additional information. There certainly will be potential issues that arise vis-a-vis timing of when the Class 6 approval will be obtained and when approval under the SAFE Act will be provided by Illinois EPA. Certainly if Illinois seeks to be granted primacy to implement US EPA's Class 6 program, that might likely resolve some of those coordination concerns, but whether that actually happens and whether that happens in the near future, uncertain for the foreseeable future. Certainly, the Illinois Safe CCS Act is what is going to govern on the state side the sequestration of gas. With that, there are, I guess, a couple more slides I want to talk about really briefly, but I want to give my colleague Bina a time just to wrap up. But a couple of things very briefly just to highlight. The first is that the Act does provide some clarity on liability for owner-operators of the sequestration facility, and it refers to and discusses joint and several liability for sequestration operators when it comes to damage that is caused by release of CO2, whether that be from the sequestration facility itself or the pipeline. And the Act also clarifies that title to the actual CO2 is vested in the owner-operator of the sequestration facility. So that is what obviously gives the pathway for liability under the Act. And then one other brief note I'll give in the couple minutes we have is just on what's called prevailing wages. Under the Act, it's referred to as a project labor agreement, but the Act provides essentially an incentive for a reduction in the fees that are associated with sequestration if sequestration work is performed under a project labor agreement, meaning it pays prevailing wages and satisfies certain apprenticeship requirements. That is a sort of a very complicated and important thing to be aware of, certainly from a monetary perspective, and something that needs to be given important consideration in this process. Bina, with that, I just want to give you time to wrap up.
Thanks, David. Yeah, so as David mentioned, there are possible rulemakings and other rulemakings that are, anticipated or will be required. So, for example, from the Illinois Emergency Management Agency will need to promulgate regulations in order to implement the Act. The Illinois Commerce Commission will, at a minimum, need to implement and promulgate regulations related to fees, and also has the ability to go beyond that. And so, these are sort of the four agencies and areas where there is a potential for additional rulemakings related to this Act to occur in the near future. And then, just before we kind of wrap up here, one of the other things David and I wanted to touch on today is just what does this mean when it comes to timing considerations for the development of a CCS project in Illinois? as we mentioned, there's a temporary moratorium on the Illinois Commerce Commission issuing certificates of authority for CO2 pipelines. But in the meantime, you've got requirements within the pipeline portion of the act that requires as a condition for approval that a pipeline owner and operator have or obtain other necessary approvals prior to operation of their pipeline. In the meantime, you have a backlog of Class 6 permits when it comes to the sequestration process. And so really, I think we're kind of at a point where, given the backlog with Class 6 permits and all of the requirements that go into getting a certificate of authority, the efforts that will need to go in to acquire pore space prior to applying to the IDNR, to the extent an integration order is necessary, where it sort of makes sense to move forward with developing certain aspects of all of the other approvals and authorizations that are required in order to develop your CCS project. David, do you have anything to add there?
No, I think you covered it correctly. Thank you, Rena.
Okay. So I think we're at the end of our hour. We did have one question come in, which I think David already addressed. And we don't want to take up, more time than we've allocated. Everyone's busy. So thank you very much for joining us today. We hope that this was useful to the folks that have joined the webinar. This last slide has our contact information on there. If you have any follow-up questions, please feel free to reach out and contact David or myself.
Thank you very much.
All right, thank you.